District Court Salon session with Steven W. Boyce, Judge presiding.
Thank you. Please be seated. All right. Good morning, everyone. We're on the record on case CR 2221-1623, State of Idaho versus Chad Daybell. This is the special sentencing proceeding that has been conducted last couple of days. The jury's been deliberating. The court is advised that the jury has reached a verdict on the special sentencing proceeding and the special verdict form. I'll note the state's present with the 4 prosecutors who've tried the case, Mr. Pryor and his client, Mr. Daybell, present as well. I'll also note there's a courtroom conduct order in effect. I'd appreciate everyone complying with that, as you all have throughout this trial. I will note on the record before we get to the verdict that we did have a jury question yesterday that the court answered, and I've provided the question and copies of the answer to counsel. In addition, a second question came in today. I did go on the record with that question and answer with counsel and the defendant present, returned that response to the jurors. They've now reached a verdict in the case, so the court is going to have the jurors brought in and have the verdict delivered for reading.
All right, please. Jury's all present. Count for Your Honor.
Thank you. Please be seated. Ladies and gentlemen of the jury, the court understands you've reached a verdict on the special verdict form. Is that correct? All right, Mr. Bailiff, if you would please return the special verdict form to the court, I'll review that. Ladies and gentlemen, the verdict form is somewhat long and complicated. The court is going to take a moment to review the form. All right, the court's reviewed the special verdict form. I do find it's been properly filled out by the jury foreperson as well as correctly signed and dated. At this time, I am going to request, Madam Clerk, Ms. Holstein, if you would please read the special verdict form. If you'd like to remain seated or standing, it's a long form and will take some time to read, but however is most comfortable for you, Madam Clerk, you may go ahead and read the special verdict form into the record.
In the District Court of the 7th Judicial District of the State of Idaho, in and for the County of Fremont, State of Idaho Plaintiff versus Chad Daybell Defendant, case number CR 22211623, Special Verdict. Part 1. We, the jury, render the following verdict on the alleged statutory aggravating circumstances. 1. Has the jury unanimously found that the state has proven beyond a reasonable doubt the existence of the following aggravating circumstance? The murder of Tylee Ryan was committed for remuneration, or the defendant employed another to commit the murder for remuneration or the promise of remuneration? Yes. 2. Has the jury unanimously found that the state has proven beyond a reasonable doubt the existence of the following aggravating circumstance? The murder of Joshua Jackson, hereinafter JJ Vallow, was committed for remuneration, or the defendant employed another to commit the murder for remuneration or the promise of remuneration? Yes. 3. Has the jury unanimously found that the state has proven beyond a reasonable doubt the existence of the following aggravating circumstance? The murder of Tamra, hereinafter Tammy Daybell, was committed for remuneration, or the defendant employed another to commit the murder for remuneration or the promise of remuneration? Yes. 4. Has the jury unanimously found that the state has proven beyond a reasonable doubt the existence of the following aggravating circumstance? The murder of Tylee Ryan was especially heinous, atrocious, or cruel, manifesting exceptional depravity? Yes. 5. Has the jury unanimously found that the state has proven beyond a reasonable doubt the existence of the following aggravating circumstance? The murder of JJ Vallow was especially heinous, atrocious, or cruel, manifesting exceptional depravity? Yes. 6. Has the jury unanimously found that the state has proven beyond a reasonable doubt the existence of the following aggravating circumstance? The murder of Tammy Daybell was especially heinous, atrocious, or cruel, manifesting exceptional depravity? Yes. 7. Has the jury unanimously found that the state has proven beyond a reasonable doubt the existence of the following aggravating circumstance? By the murders or circumstances surrounding their commission, the defendant exhibited utter disregard for human life? Yes. 8. Has the jury unanimously found that the state has proven beyond a reasonable doubt the existence of the following aggravating circumstance? The defendant, by his conduct, whether such conduct was before, during, or after the commission of the murders at hand, has exhibited a propensity to commit murder which will probably constitute a continuing threat to society? Yes. If you answered no to each of the above questions, you do not need to answer any other questions. Simply have the presiding juror sign this verdict form and notify the bailiff that you are done. If you answered yes to any of the above questions, then please answer the questions in part 2. Part 2. We, the jury, render the following verdict on the weighing of all mitigating circumstances against the statutory aggravating circumstances. You are to only answer the following questions for those statutory aggravating circumstances for which you answered yes in part 1. 1. With respect to the statutory aggravating circumstance that the murder of Tylee Ryan was committed for remuneration, or the defendant employed another to commit the murder for remuneration or the promise of remuneration, we unanimously find that when weighed against this aggravating circumstance, all mitigating circumstances are not sufficiently compelling to make imposition of the death penalty unjust. 2. with respect to the statutory aggravating circumstance that the murder of Joshua Jackson, hereinafter JJ Vallow, was committed for remuneration, or the defendant employed another to commit the murder for remuneration or the promise of remuneration, we unanimously find that when weighed against this aggravating circumstance, all mitigating circumstances are not sufficiently compelling to make imposition of the death penalty unjust. 3, with respect to the statutory aggravating circumstance that the murder of Tamara, hereinafter Tammy Daybell, was committed for remuneration, or the defendant employed another to commit the murder for remuneration or the promise of remuneration, we unanimously find that when weighed against this aggravating circumstance, all mitigating circumstances are not sufficiently compelling to make imposition of the death penalty unjust. 4, with respect to the statutory aggravating circumstance that the murder of Tylee Ryan was especially heinous, atrocious, or cruel, manifesting exceptional depravity, we unanimously find that when weighed against this aggravating circumstance, all mitigating circumstances are not sufficiently compelling to make imposition of the death penalty unjust. 5, with respect to
Did we lose the mic?
it's back. 5, with respect to the statutory aggravating circumstance that the murder of JJ Vallow was especially heinous, atrocious, or cruel, manifesting exceptional depravity, we unanimously find that when weighed against this aggravating circumstance, all mitigating circumstances.
We need a new mic. Okay, we're going to get a separate mic. Thank you.
I'll read 5 over.
Yes, start with 5 again. Thank you, Madam Clerk.
5. Okay. With respect to the statutory aggravating circumstance that the murder of JJ Vallow was especially heinous, atrocious, or cruel, manifesting exceptional depravity, we unanimously find that when weighed against this aggravating circumstance, all mitigating circumstances are not sufficiently compelling to make imposition of the death penalty unjust. 6, with respect to the statutory aggravating circumstance that the murder of Tammy Daybell was especially heinous, atrocious, or cruel, manifesting exceptional depravity, we unanimously find that when weighed against this aggravating circumstance, all mitigating circumstances are not sufficiently compelling to make imposition of the death penalty unjust. 7, with respect to the statutory aggravating circumstance that by the murders or circumstances surrounding their commission, the defendant exhibited utter disregard for human life, we unanimously find that when weighed against this aggravating circumstance, all mitigating circumstances are not sufficiently compelling to make imposition of the death penalty unjust. 8, with respect to the statutory aggravating circumstance that the defendant, by his conduct, whether such conduct was before, during, or after the commission of the murders at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. We unanimously find that when weighed against this aggravating circumstance, all mitigating circumstances are not sufficiently compelling to make imposition of the death penalty unjust. Once you have completed part 2, please have the presiding juror sign this verdict form and notify the bailiff you are done. Dated this first day of June 2024 and signed by the presiding juror.
All right, thank you very much, Madam Clerk, for reading through the verdict form. Ladies and gentlemen, the court will note that given the complexity of this special verdict form, just I think in fairness to all those in attendance, including in particular victims and the parties, the layman's explanation of this verdict is that the jury has made a finding that it would be appropriate to impose the death penalty as it relates to counts 1 through 6 in the amended indictment. And so pursuant to Idaho Code 192515, the court is directed that the defendant would be sentenced to death on those counts. The court will take up a concluding sentencing proceeding. I also have additional counts of insurance fraud. I've discussed with counsel moving forward in a consolidated hearing. The court's proposing that we do that this morning, waiving the right to a pre-sentence investigation report under Criminal Rule 32A. Before I get there, just let me ask at this time of the jurors, is this your true and correct verdict that's been rendered in this case? Very well. Does the state wish to have the jury pulled on the special verdict form?
No, Your Honor. Thank you.
Does the defense wish to have the jury pulled on this special verdict form?
No, thank you, Your Honor.
Very well. As I mentioned, then that's the result of the verdict form. The court would then proceed with additional sentencing on those two counts, as well as the counts 1 through 6 determined now by the jury. Mr. Pryor, is the defense willing to move forward with a consolidated hearing on those counts this morning without a pre-sentence investigation report?
As previously indicated, Judge, yes, we are.
Okay, is the state going to be ready to proceed with a sentencing on those issues as well?
Yes, Your Honor. Thank you.
Okay, thank you. Counsel, I do want to take a brief recess just to briefly prepare for that, given the verdict, and I will come back on the bench. It really won't take long. I would suggest that a 30-minute recess will come back on the record. The court will conclude with that sentencing hearing. So if everybody could be back here by 10 after, we'll have the jury return one last time to the jury room to wait for that final sentencing hearing. We'll conduct that in the presence of the jurors also, and then I'll have concluding instructions for the jurors. So we will be in recess for 30 minutes. We'll come back for that final stage of the proceeding. Thank you.
All right.
Thank you. Please be seated. All right, we're back on the record on CR 22-21-1623, State of Idaho versus Chad Daybell, concluding the special sentencing hearing that's being conducted where the court intends to sentence the defendant on the counts in the amended indictment, including the insurance fraud counts. Is the state ready to proceed?
Yes, Your Honor.
Is the defense ready to proceed?
Yes, Your Honor. Thank you.
Very well, Mr. Bailiff, if you'd please have the jurors brought in.
Yes, Your Honor. All right, please. Jury's all present accounted for, Your Honor.
Thank you. Please be seated. Okay, we are back on the record on CR 22-21-1623, continuing the special sentencing proceeding. The jury has returned its special verdict. The court would note that pursuant to Idaho Code 18-4004, which is the punishment for murder statute in Idaho, that crime in murder of the first degree can be punished by death. And under Idaho Code 19-2515 subsection 7A, that states that if the jury finds that a statutory aggravating circumstance exists and no mitigating circumstances exist, which would make the imposition of the death penalty unjust, the defendant will be sentenced to death by the court. The court's reviewed the findings of the jurors in the special verdict form. They've taken their time through these deliberations to return that verdict. And so the court will proceed with sentencing first on counts 1 through 6. And again, this is an unusual hearing because the sentencing hearing's already been taking place. We've heard from the victims through impact statements and arguments from counsel. That's already taken place. In addition, a pre-sentence investigation report is not to be ordered in these hearings, so the court does not reference that. The court then orders as follows, and this will be contained in the court's judgment at the conclusion of the case. As to count 1, the conspiracy to commit first-degree murder and grand theft by deception for the murder of Tylee Ryan, upon the jury's finding of guilty and return of the special verdict form, the jury finding beyond a reasonable doubt and having returned the special verdict that the aggravating circumstances when weighed against the mitigating circumstances do not make the imposition of the death penalty unjust. The court, therefore, on count 1, the defendant is sentenced to death. On count 2, the first-degree murder of Tylee Ryan, the jury finding beyond a reasonable doubt and having returned the special verdict that the aggravating circumstances when weighed against the mitigating circumstances do not make the imposition of the death penalty unjust. The court, therefore, on count 2, sentences the defendant to death. On count 3, the conspiracy to commit first-degree murder and grand theft by deception for the murder of JJ Vallow, the jury finding beyond a reasonable doubt and having returned the special verdict that the aggravating circumstances when weighed against the mitigating circumstances do not make the imposition of the death penalty unjust. The court therefore on count 3 sentences the defendant to death. On count 4, first-degree murder of JJ Vallow, the jury finding beyond a reasonable doubt and having returned the special verdict that the aggravating circumstances when weighed against the mitigating circumstances do not make the imposition of the death penalty unjust. The court therefore, on count 4, sentences the defendant to death. On count 5, conspiracy to commit first-degree murder of Tammy Daybell, the jury, having found beyond a reasonable doubt and having returned the special verdict that the aggravating circumstances when weighed against the mitigating circumstances do not make the imposition of the death penalty unjust, the court therefore, on count 5, sentences the defendant to death. On count 6, the first-degree murder charge, the murder of Tammy Daybell, the jury, having found beyond a reasonable doubt and returned the special verdict that the aggravating circumstances when weighed against the mitigating circumstances do not make the imposition of the death penalty unjust, the court therefore, on count 6, sentences the defendant to death. The court's next going to take up counts 7 and 9 on the insurance fraud counts. Before I do that, from the state, are there any questions regarding the court's judgment as it relates to counts 1 through 6?
No, Your Honor. Thank you.
Questions from the defense?
No, Your Honor. Thank you.
All right, moving on to insurance fraud, then the court will note that I am required to go through a sentencing proceeding on this. These are separate counts that have not been determined in the special verdict form by the jurors. Some brief procedural history. Mr. Daybell was charged by amended indictment with counts 7 and 9 insurance fraud under Idaho Code 41293, which is a felony. Mr. Daybell pled not guilty to those counts on June 9th, 2021. Thereafter, this trial was held, and as part of the findings of the jury in their verdict, they did find the defendant guilty of both of those counts. The court has considered, in lieu of a pre-sentence investigation report, the information that I've heard throughout this trial. I also heard information regarding these charges in the previous trial held last year against co-defendant Lori Vallow. I've also heard information received during the special sentencing proceeding relating to those counts as well, and have considered that information in lieu of a pre-sentence investigation report. And I'll also note the defendant waived the pre-sentence investigation report and is permitted to do that, and the court can allow that under Criminal Rule 32A. At this time then, before I move forward with the sentencing on counts 7 and 9, I will inquire of the state. Is the state wishing to make any sentencing recommendation as it relates to count 7 or 9?
And Your Honor, just for clarification, were the insurance frauds count 8 and 9?
As listed in the amended indictment, they are listed as count 7 and count 9.
Thank you. Co-counsel just clarified for me on that. Your Honor, the state is prepared to make a statement. First, I would indicate for the record that in relation to the sentencing hearing, the sentencing portion handled yesterday, the state did make our best attempts to reach out to all statutory victims to allow them the opportunity to be heard by the court. And those that the court heard from yesterday were the ones that had wished to make impact statements. While not directly related to the insurance fraud, I did just want to make a clear record of that. In relation to the insurance fraud charges, in light of the sentence that has been imposed by this court and by the recommendation of the jury in relation to the other charges, the state would indicate we think that the victim statements covered everything the state could say. While the insurance charges again are attenuated to it, we've lost 3 individuals that the state can do nothing to bring them back. And so the best we can do is move forward in seeking justice on their behalves. In relation to the insurance counts themselves, given the sentences, we would recommend this court impose jail time and have that, or prison time, excuse me, impose a sentence and run it concurrent with the imposition of the other sentence by this court. I believe they carry up to 15 years in prison. We'd recommend they run concurrent with each other and with the imposition of death in this case. We would also recommend restitution in the amount of $130,000 to Life Map and $300,000 to Primerica. As part of that, we would also recommend a waiver of any fines or court costs in this matter in order to allow restitution to be paid if any money is available to go towards that.
All right, thank you for the state's sentencing recommendations. Mr. Pryor, does the defense wish to make sentencing recommendations as to, I'll do them collectively, counts 7 and 9, the insurance fraud counts?
No, Judge, there's nothing further. Thank you, Your Honor.
All right, is there any objection to the requested restitution amounts of 130,000 and 300,000?
Judge, we may need to set that out at this point, but I'll let the court know if that changes.
All right, I'll permit 30 days for the scheduling of a contested hearing on restitution. If that becomes an issue, we could conduct that hearing most likely remotely on a Zoom hearing if it becomes an issue. At this time, I will ask, because I need to on these counts, before I impose any sentence, Mr. Daybell, you do have the right of allocution, which permits you to make a statement on your own behalf in any mitigation of these offenses. Is there any statement you would like to make before I proceed with sentencing on those counts?
No.
Very well. The court then, having considered the information previously referenced, finds that pursuant to Idaho Code 41293, which under subsection 4 indicates a penalty of up to 15 years of prison. On each of those two counts, the court is going to impose a prison sentence of 15 years. So a 15-year sentence will be imposed on count 7. The court will take under advisement the issue of restitution requested by the state. The court will not impose any fines. The court also will impose a 15-year prison sentence on count 9. Also pursuant to the same statute, take under advisement the issue of restitution. The court will note in imposing these prison sentences that I have reviewed Idaho Code 192521, which requires me to go through certain criteria about the imposition of a prison sentence versus a possibility of parole or a lesser sentence. And I would note that the rationale for the prison sentences is that these are intertwined with the murder charges for which the death penalty has been imposed on those counts. And when the court looks at the sentencing factors under 1925-21, I would note in mitigation that Mr. Daybell has been incarcerated an extensively long time in local jail and has a previous law-abiding history, and I have considered that. I've also considered that he's always conducted himself respectfully, from what I've heard from all of the jailers that have ever interacted with him over the years that he's been incarcerated for these charges. However, the court finds under Idaho Code 2521 also that any lesser sentence would depreciate the seriousness of these offenses, because this life insurance was obtained based on the murders of individuals and procuring life insurance payouts unlawfully. And because of that, it's the most serious offense, that circumstance that could lead to that. In addition, imprisonment will provide an appropriate punishment and deterrent for the defendant and others, and will also be a deterrent for the community as well. So the court, having then concluded with the sentencing on that, I will not order any fines, because the defendant's previously been deemed indigent and has received the death penalty on these murder counts, and find it would be futile to have an order of fines in the case. So with those remarks, then the court typically would address the defendant further, but in the special sentencing proceeding, the victim impact statements and the evidence has already demonstrated on the record, I think, the seriousness of what's occurred. And I don't find any reason to further delve into the court's rationale other than what was listed in the statute. So unless there's anything further, that will conclude the sentencing, but I will address the post-conviction issues that need to be addressed at this time. Does the state have anything further then on the sentence and count 7 and count 9?
No, Your Honor. Thank you.
Anything further from the defense?
No, Your Honor. Thank you.
Okay. Mr. Daybell, in this case, given the sentence that was imposed in counts 1 through 6, there's a special appellate and post-conviction procedure for capital cases, and an automatic stay may be in effect. There's a statute that's Idaho Code 192719 that sets out certain deadlines. I am providing you and counsel with a courtesy copy of that statute, but I will note a few of the deadlines that are listed in there. Under subsection 1, when the punishment of death is imposed, the time for filing an appeal shall begin to run when the death warrant is filed. Number 2, the death warrant shall not be filed until 42 days after the judgment imposing the death sentence has been filed. Number 3, within 42 days of the filing of the judgment imposing the punishment of death, the defendant must file any legal or factual challenges to the sentence of conviction. There's other important and critical deadlines that are contained within that statute, and I am going to provide a copy of that to Mr. Pryor to ensure that the defense is well advised of those post-conviction rights that would apply in this special proceeding. I'll also note that there's an additional rule, Idaho criminal rule. If you'll give me a moment, I think it's 44.2. Criminal Rule 44.2, and that's the mandatory appointment of counsel for post-conviction review after imposition of the death penalty. That rule is also applicable in your case, and a copy of the rule itself is going to be provided to you and counsel to ensure that you're well aware of any post-conviction rights you may have. With that, then, the court is going to conclude the special sentencing proceeding. Is there anything further I need to take up from the state?
No, Your Honor. Thank you.
Anything further from the defense?
No, Your Honor. Thank you.
Okay, thank you everyone for your abiding by the court's courtroom conduct order. We'll be in recess.
All right. Thank you all. Folks, thank you all.